Most people don't like to talk about their mortality, and as a result, most people tend to ignore their estate planning needs. But if you're over the age of 18, then estate planning is a very important consideration that you need to make. Put simply, an estate plan is your instructions as to what you want to happen to your assets if you were to pass away, and also what happens if you were to lose the ability to make decisions for yourself. Now, depending on the complexity of your situation, an estate plan involves many moving components and it can be quite a complex area of advice. So today I'm going to be looking at one aspect of estate planning, and that is the will. Now there are many other aspects like enduring powers of attorney, enduring powers of guardianship, nomination of beneficiaries, all that kind of stuff. And I will be looking at these elements in future videos. But I figured if I try to cover everything in this video, and that was initially my intention, then it is a monster of a thing to get through, and I'll just be brushing over too many details to fit it all into one video. So instead I'm going to break it down into smaller, more digestible parts. Hello guys, Brad here from The Guided Investor. Welcome back to the channel for another video. If you're new here, consider hitting that subscribe button because I post regular videos about how you can do more with your money. And today we are talking about wills. Now, most people know what a will is. It's a way to ensure your assets are passed on to your preferred person or persons in the event you were to pass away. And now wills generally cover things like these: who receives your assets, who will care for your minor children, funeral plans, donations to charities, and the establishment of trusts. And when drafting a will, you're going to come across a number of technical terms that you need to be aware of. So let's cover off some of those terms now. The beneficiary. This is the person or the people who are going to be receiving the inheritance. The estate. This is the assets that you own at time of death. The executor is the person named responsible for winding up the affairs of the deceased person. A guardian is a person named to care for minor children. Probate is the document by which the court recognises the authority of an executor to act under a will. A spouse can include a husband or a wife, a person in a civil partnership, or a de facto partner. Now, of course, this also includes same-sex couples. And testator is the person who makes a will. When it comes to drafting your will, there are essentially two ways you can do it. And the first and most cost-effective way is to get yourself a DIY will kit. And they cost you about $32, and they come with instructions and a template to write your own will. But before going down the DIY will kit path, you need to be prepared to put in the time and the effort that it takes to draft the will properly. So this is going to mean that you read all the instructions, you follow the instructions, and you take care when you're preparing your will. Because if you don't do this and you make a mistake, then your will can be deemed invalid. If your situation is a little more complex, or you simply don't trust yourself to write the will properly, then you can always get professional help. There are many different estate planning specialists that can help you write a will. And some of them even have online systems where you punch your data in online, they check it behind the scenes, and you can get your will fairly cost effective, but also checked by a professional. Each state also has what's called a public trustee, and this is a government appointed estate planning arm that will do this job for you at a reasonable cost. Technically speaking, you can make your will as detailed as you like. So for example, I want Auntie Betty to receive my diamond ring, and I want Uncle Billy to receive my gold watch. Now, that's not always the best idea, and whenever people are drafting wills, I always advise them to keep it as simple as possible. The more complex a will, the more it's going to cost you to draft, and also the higher the chance the will is deemed invalid. So often simple wills are the best way to go. But there are certain circumstances where your financial situation or your relationships will dictate the complexity of your will. If you've been through a divorce, if you've got children with different partners, if you operate a business, if you own assets through a company or a trust, then these are all examples of when your situation is a little more complex. And if this applies to you, then I would strongly suggest that you go and seek professional help when drafting your estate planning needs. Once you have a will, you need to make sure that you store it safely. So you can store it at home, preferably in a safe or in a locked cabinet, or you can pay an attorney to store it on your behalf. Now, if you do decide to store it at home, make sure that you give someone trustworthy a key, otherwise they're not going to be able to access the will should something happen to you. While wills don't have an expiration date, it is important that you review your will on a regular basis. Often there are significant life events that are triggers for you to review your will, and some of those events are as follows. In the event of marriage, the birth of a new family member, significant changes to your assets, divorce or separation, death of a beneficiary, moving to a new state or territory, or if a named person in the will is unable or unwilling to act. If you do create a new will, then your new will supersede your old will, and it will normally start with something along the lines of, I hereby revoke all previous wills and codicils. If you fail to write a will and you pass away, you're said to die intestate. And under this scenario, your assets would be distributed in accordance with the rules of intestacy. Now, each state and territory has their own set of rules of intestacy, but it's not the best idea to rely on these rules simply because it can mean that your assets go to people that you don't want them to go to, and two, there can also be some significant costs in this process. As a side note, if you have property owned jointly with another person, so for instance, if you own your house jointly with your spouse, then this doesn't form part of your estate. It's automatically passed on to the surviving owner. Also, if you have a valid nomination of beneficiary on your superannuation funds and your life insurance, then there's a chance that this also bypasses the will and goes direct to your nominated beneficiary. So in summary, wills are a very important aspect of your estate plan. Now, even if you have very little assets, you should still get a will done to avoid the unnecessary complexity and cost that comes with passing away intestate. But that's it for me, guys. Thanks a lot for watching. I hope you liked this video, and I will see you guys in the next one.